We want to call the hearing to order, and the Chair recognizes himself for 5 minutes. Here in the Environment and Economy Subcommittee, our goal is to modernize some of the environmental laws that we oversee and make sure that the states are playing a significant role in implementing them. To do that, we began this Congress with a hearing on the role of states in protecting the environment. State environmental protection officials shared their experience and expertise with us and helped us better understand the complex partnership between states and the federal government as states implemented federal laws, such as the Solid Waste Disposal Act, and EPA implements the Comprehensive Response Compensation and Liability Act, CERCLA, or the Superfund law, and the relation to state and environmental protection laws. Today we consider 3 bills that are a logical outgrowth of that discussion. One, the Federal Facility Accountability Act would bring CERCLA waiver of sovereign immunity into conformity with Solid Waste Disposal Act, and for that matter, the Clean Air Act, by requiring that all federal Superfund sites comply with the same state laws and regulations as a private entity. This is not a new concept. Legislation has been introduced previously by my friends across the aisle to ensure that federal agencies comply with all federal and state environmental laws. The second bill, the Federal and State Partnership for Environmental Protection Act, does exactly what the title implies and would go a long way toward making the states partners with EPA in cleaning up hazardous waste sites. CERCLA is implemented by the EPA, but often states are in the best position to understand the sites in their state. This bill would allow states to play a larger role in the CERCLA process in several ways. The bill would allow states to list a site it believes needs to be on the national priorities list every 5 years and would provide transparency to the states if they suggest a site for listing. The bill would also allow states to be consulted before EPA selects remedial action. The states who are on the front lines understand at the ground level how to prioritize in taking environmental action within their state, and they often come up with innovative solutions that better fit the local problem. We heard examples in our earlier hearing on the role of the states in protecting the environment. CERCLA is a key example of the statute passed more than 30 years ago that we are in the perfect position to now update and strengthen the federal-state partnership and get these sites cleaned up. Besides, the states are required to sink their money in these clean-up projects, and while we understand there are budget constraints at all levels of government, if states have a significant cost, they should have more of a say in how the cleanup money is spent. Continuing the theme of updating our environmental statutes passed in the 70s and 80s, the third bill, the Reducing Excessive Deadline Obligation, or the REDO Act of 2013, would get EPA flexibility by correcting a couple of arbitrary action deadlines that were written into the Solid Waste Disposal Act and CERCLA years ago. The mandate that EPA review and, if necessary, revise all RCRA regulations every 3 years has proven unnecessary and unworkable. The bill would allow the administrator to review and, if necessary, revise regulations she thinks appropriate. It also reduces a requirement that only seems to be good for generating lawsuits against the EPA. In fact, they did submit testimony. I would have people look at the testimony provided by the Environmental Protection Agency, and I quote that the current statutory provisions requiring review every 3 years can pose a significant resource burden on EPA given the complexity and volume of EPA's RCRA regulations. So they are in agreement that this is overly burdensome and costly. Shimkus and the EPA on the same side. It's a beautiful thing. The bill also lists an action deadline in CERCLA requiring EPA to identify prior to 1984 classes of facilities for which to develop financial assurance regulations. More than 30 years passed without action from EPA. As we approach the 30th anniversary of the original deadline in CERCLA, a lawsuit and court order finally prompted EPA action of a few years ago. However, the states have long since acted, putting in place strong financial assurance requirements of their own. That is why the bill also provides that if EPA does get around to establishing federal financial assurance regulations, the state requirements should not be preempted. We regret that it was not possible for a friend of this committee, Mr. Stanislaus, Assistant Administrator at EP, to be with us today. but as I quoted, we have his written statement, and we'll consult with him and his staff as these bills move through the legislative process. Throughout that process, we also welcome suggestions from our witnesses today and other experts in the field, and that's why we're having this legislative hearing. I want to lastly thank our witnesses for being with us today and appreciate your willingness to travel to Washington to share your opinions on the 3 bills before us. With that, the chair now recognizes the gentleman from New York, Mr. Tonko.
Thank you, Mr. Chair, and good morning to our witnesses. And let me begin by saying how pleased I am that we were able to come to an agreement and that we will have an opportunity to receive testimony on the Superfund program from additional witnesses before we mark up our bills. I appreciate your willingness to accommodate the desire of the subcommittee members to hear from witnesses about the current status of this program. The Comprehensive Environmental Response, Compensation, and Liability Act, commonly known as Superfund, is an important statute guiding the cleanup of contaminated sites throughout our country. It is fair to say that this law had a rough start. Over the years, it has been shaped by amendments, agency guidance, regulations, and extensive litigation. Much of the dust has now settled. Cleanups are proceeding across the country. Many communities are safer as a result of this law, and contaminated, abandoned sites have been returned to productive reuse. I want to thank the witnesses for appearing before our subcommittee this morning and for offering their views on the 3 bills before the subcommittee. Mr. Chair, you characterized the bills as simple reforms to Superfund, and I am new to the committee but not new to the contamination problems that Superfund was enacted to address. Simple is not an adjective I usually associate with Superfund, and I hope we're not embarking on an effort that will negate the progress we have made on site cleanups and the reuse of brownfields. One bill that we will consider today, for instance, is couched as legislation designed to repeal so-called, I quote, excessive deadlines. Section 2 of this bill appears to be designed to block a lawsuit from coal ash recyclers to bring some certainty to their markets. Those recyclers have gone to court over EPA's failure to meet a statutory deadline that they say has, and I quote, constrained the recycling of coal ash with the intended result of wasted resources, adverse economic impacts, and increased environmental impacts that would otherwise be avoided through beneficial reuse, close quote. Many of us support the beneficial reuse of coal ash, which is what the coal ash recycling industry does. This industry has gone to court to protect their rights and seek a legal remedy for their plight. We should not throw their case out of court by legislative fiat. Other provisions we'll consider today will delay cleanups in favor of litigation, will decrease the funding available for cleanup efforts, and will divert resources so that the most dangerous contaminated sites are not cleaned up first. There are many questions that surround these bills. They may delay efforts to adopt financially responsibility requirements for environmentally damaging mining, and they could preempt those requirements once adopted. But again, I look forward to hearing what everyone has to share with us today, and with that I yield back, Mr. Chair.
Gentleman yields back his time. Is there anyone on my side seeking time for an opening statement? The Chair now recognizes the Chairman Emeritus, Mr. Dingell, for 5 minutes.
Mr. Chairman, thank you for your courtesy. I'm giving a statement on behalf of myself, but I'm using Mr. Waxman's time. I have some familiarity with the subject matter before us today, since I chaired both the committee and the conference committee, which lasted some 8 months when we considered the Superfund Amendments and Reauthorization Act of 1986. For many of the members of this subcommittee on both sides of the aisle that were not in the Congress in 1986, I'd like to recall some of the events of that legislative effort resulting in the 1986 Act, and to describe the result of more than 3 years of legislative hearings and 5 years of oversight hearings. The issue was enormously complex and bitterly controversial. It was also a fully bipartisan effort on the committee, and we worked very closely with the Reagan administration, which I saw was present at all the conference meetings. And the then chairman, the then head of EPA, was a valuable assistance to the committee and the conference committee in writing final legislation. The Senate at that time was under Republican control. President Reagan signed the act on October 17, 1986, after overwhelming votes of 386 to 27 in the House and 88 to 8 in the Senate. One of the interesting things about that was my difficulty was to see to it that the legislation was considered in a balanced and thoughtful way, but the pressures oftentimes were to go too far. I am unaware that this committee has, or any of the subcommittees, have conducted any oversight that has identified problems necessitating the amendments before us today. I believe every member of this committee can point out things that need to be done with regard to the legislation. I have some of my own. The Superfund program, after a rocky start, has become a very successful and an enormously important public health program, cleaning up some devastatingly dangerous situations all around the country. And I would note that some of the worst difficulties that agency confronts in administering this legislation is that there is no money. We have been both stingy in seeing to it that appropriated funds are available, but worse than that, we've allowed the tax revenues, which funded the original Superfund, to dry up. So the money is not available to see to it that the matter is properly handled. And these are hideously technical and politically difficult questions. And I would suggest that before heading headlong into the resolution of problems, that don't find any support in a factual record at this time, that the committee should gather the evidence from the states, from EPA, from local governments, from industry, and I think industry's comments will be very important, from the communities and from ordinary citizens, so that we can understand what, if any, problems need to be addressed, and how the interlocked and difficult questions, political, technical, environmental, and financial, work together. And I think that the tools necessary to ensure that federal sites are properly listed and expeditiously cleaned up are available to us and can be perfected by a thoughtful and a decent approach to the legislation before us. And we can understand then perhaps why it's taken more than 25 years of fighting in all of these matters to establish financial responsibility requirements for industries that deal in hazardous substances. My district is an industrial district where we have large numbers of old industrial sites, and these curse us all and require enormous amounts of effort, cooperation, and understanding for us to solve the problems and clean them up. But we are making progress, and we will continue to do so if we don't screw these matters up by legislating in an unwise and irresponsible fashion. I hope that my colleagues will try to understand the purpose of this hearing and the purpose of legislation and legislative change. And these are more than just to provide work for us or work for the staffs. And I think we have to worry because the committee, or the subcommittee, seems to be doing well in creating a lot of staff work, but not a lot of thoughtful effort or understanding of the problem so that we can legislate well. This is a massive health problem, a massive environmental concern. It is a tremendous financial problem, and it's something that does need our attention. But that attention must be thoughtful. It must be considerate of the concerns of everybody, but it must also address the question of facts and what really has to be done to achieve a balanced and perfected approach to this matter in which we'll do the job better than we did the first time. I yield back the balance of my time.
Gentleman's time yields back his time, and I would just quickly note that I'm not a spring chicken on this committee either, and my first piece of legislation was a response to the Superfund. When we got small business out of the liability regulations that de minimis parties, and that was a successful piece of legislation, that we were able to pick out what was wrong and how we could fix it, and I would just refer folks to the EPA's testimony where it says the current statutory provisions requiring review every 3 years can pose a significant resource burden on the EPA, given the complexity and volume of EPA's RCRA regulations. So So it's not just us. It's even the EPA saying that this might be helpful. So with that, I'd like to recognize and welcome our folks and our witnesses. And I'll just go in order. I already talked to you about votes being called soon. We'll get through as many as we can, so then when we come back, we go back to questions. So first, I'd like to welcome Ms. Carol Hansen, Deputy Executive Director and Environmental Council of the State. Your full testimony is in the record, and you're recognized for 5 minutes.
Thank you. Thank you for inviting me here today to talk about our organization's views on the bills before the committee. I'm representing the Environmental Council of the States, or ECOS, whose members are the leaders of the state and territory.
Can you pull your microphone just a little bit closer, maybe lift it up, and pull it closer? There you go.
It's not staying on. There we go. I'm representing the Environmental Council of the States, ECOS, whose members are the leaders of the state and territorial environmental protection agencies. My main points today are, first, that ECOS supports concepts found in the 3 bills addressing RCRA and CERCLA issues. Second, in particular, ECOS supports the expansion of consultation with states as described in the bills, and also that ECOS especially acknowledges that the bills directly address concerns expressed by the states in 2 of ECOS's resolutions on federal facilities operations under RCRA and CERCLA. These resolutions were attached to our written testimony. We are pleased that the committee has taken an interest in addressing RCRA and CERCLA in a manner that focuses on implementation issues that states and EPA regularly face. We are in an era where funds to implement our nation's environmental statutes are tight, but the sites needing remediation these days are more complex than when the program started. We are in need of flexibility and efficiency more than ever, both at the state and federal level. Overall, we support the changes that these bills seek, and we believe they will improve the implementation of RCRA and CERCLA and help achieve the goals of those statutes more quickly. First, I'll address the bill entitled the Reducing Excessive Deadline Obligations Act of 2013. Simply put, this bill allows EPA to emphasize the administrative priorities that warrant its attention and to establish in statute a longstanding practice at EPA regarding matters that it may undertake at its discretion. The next bill I will address is entitled the Federal and State Partnership for Environmental Protection Act of 2013. The first part of this bill addresses consultation with the states. ECOS strongly approves this section, which addresses issues outlined in several ECOS resolutions. The second part of this bill addresses state credit for other contributions. It is our understanding that this bill does not expand the state's cost share for removal actions beyond what is currently required, and our comments are made with this understanding. This change will greatly assist during this time of tight budgets and should help move these projects along more quickly. Furthermore, assuming the legislation does not intend to create an additional cost share in removal actions, ECOS supports the legislation because if the state performed an action such as site stabilization that EPA later classified as a removal action, then there may be an opportunity to get credit for those state expenditures. We also endorse Section 4, placing a site on the national priority list is important to a state, as this action must go all the way to the governor's office. ECOS believes that EPA's policy has been to seek state concurrence when listing a site for the MPL. However, this is a policy, and we believe the nation would be better served if it were a requirement. The last bill I will discuss is the Federal Facility Accountability Act of 2013. ECOS is especially pleased to see the committee address this long-standing issue. This bill directly addresses the concerns ECOS described in 2 of our resolutions. ECOS believes this legislation will help states assure environmental compliance on current and former federal facilities. The most important aspect of this legislation is that it sends a strong and appropriate message to all federal agencies. You must follow the nation's environmental rules the same as everyone else. The legislation amends CERCLA to eliminate most, if not all, of the barriers that states have experienced in dealing with federal agency compliance with the Act. It is especially useful to states to see that compliance and cost sections change to conform with the experiences that non-federal entities face every day. Finally, we support the ability for a state to request a review by EPA to ensure consistency of some federal action with the guidelines, rules, regulations, or criteria established by EPA under Title I of CERCLA. This section closes a potential loophole in advance. In summary, ECOS sees that these bills will assist in many ways, including holding federal facilities to the same standards as other regulated entities, clarifying regulations and procedures, improving state-federal communications, improving cleanup financing, and implementing state EPA concurrence on how to treat Superfund sites, to name a few.
Thank you. And Chair now recognizes Mr. Jeffrey Steers, Director, Central Office Division of Land Protection and Revitalization from the Virginia Department of Environmental Quality, on behalf of the Association of State Territorial Solid Waste Management Officials. Sir, welcome.
Good morning, and thank you, Mr. Chairman and members of the subcommittee, for allowing the SWAMO, the Association of State and Territorial Waste Management Officials, to testify before you today regarding these three bills. States value the relationship that we currently have with U.S. EPA, and together, through several types of cooperative agreements, both as individual states and as an association, continue to make great strides in addressing some of the most contaminated land in the United States. While we can all agree that the Superfund program has success stories, 30 years of use necessitates some changes and updating. The decisions made by Congress and EPA can have a profound impact on state resources. States share a common goal with the federal government in ensuring that risks to human health and the environment are mitigated and appropriately addressed. Our association is committed to ensuring that this is done in an efficient, cost-effective manner, and I will briefly summarize our position on each specific bill. With respect to this Reducing Deadline Obligations Act of 2013, we support this bill. Specifically, our interest surrounds the proposals that allow the individual states to maintain financial assurance requirements already in place so as not to allow federal preemptions to override state financial assurance programs. Member states have enacted robust financial assurance requirements for various classes of facilities and other types of facilities under RCRA. The impacts of any new federal requirement must be carefully coordinated and evaluated in the context of existing state laws and obligations. SWAMO supports the provisions proposed in the Federal and State Partnership for the Environmental Protection Act of 2013, especially with respect to fund lead sites placed on the national priorities list. Our members continue to be challenged with skyrocketing financial obligations, which include 10% cost share of the remedial action and O&M in perpetuity. EPA consultation with states on removal actions, listing to the NPL, and on remedy selection doesn't in fact occur regularly. The end result of this consultation is often problematic and inconsistently used across the EPA regions. The states have no interest in delaying emergency or time-critical removal actions, for example. However, non-time-critical removal actions are not viewed as urgently, and state concurrence and development of a plan for the status of some of these sites after a removal action is taken are needed. With respect to NPL listings, the SWAMO supports greater consistent consideration by EPA relative to state obligations to the inclusion on the NPL. States are under a significant pressure to just concur with individual listing decisions. Circular authority is one tool to address contaminated lands. As states evaluate proposals for listing, we look for other opportunities, including economic redevelopment opportunities to help drive cleanups. Oftentimes, there is a prospective purchaser willing to adequately mitigate the environmental and human health risk on a contaminated property, provided they have future certainty and avoid the stigma of Superfund. State voluntary programs can, in many circumstances, serve as a substitute for the long and costly CERCLA Superfund processes. States should not be pressured into accepting at face value a listing on the NPL, especially where the fund is being used and resulting in significant state resources. The provisions of this bill that seek to give states the ability to add sites to the NPL is fully supported by SWAMO. While there may be perceived notion that there are dozens of state priorities that would be suggested for listing, this is simply not the case. States recognize the limited resources that we all have and understand that we have complex sites that we need to get the biggest bang for the buck. The SWAMO strongly supports a process for more concurrence with selected remedies, especially at fund lead sites. Many of our member states have sophisticated programs, and we can offer the technical firepower that ensures remedies will be effective. All too often, we come across sites that are turned over to the states that are nothing more than a pig in a poke, and the state is responsible for the long-term care. An example of a $100,000 problem that our state and other states have seen is something as simple as piping that was clogged and was not able to be properly maintained during the time that EPA had a site under its control, and the state took the site over and had to refix a lot of the problems. We strongly support the Federal Accountability Act of 2013. No entity, whether privately or publicly owned, should be given special treatment when it comes to protecting human health and the environment. Federal agencies playing the sovereign immunity card only serve to delay and put citizens in harm's way. States continue to believe that the federal government should be accountable to adherence with CERCLA, similar to what is required under the Clean Air Act, Clean Water Act, and RCRA. The universe of sites subject to CERCLA includes properties owned by federal, state, and local governments and private entities. The protection of our citizens should not be seen through the color of ownership. Many states and localities are also limited with the resources that they can bring to bear, so we all need to work together in our obligations. It is inherently wrong for the federal government to shirk its responsibilities due to cost considerations. It is important that federal facilities and agencies be accountable to the same requirements as all other regulated entities, including state-specific requirements to ensure equal treatment and protection under the law. In closing, let me just say that the CERCLA process is complex, and we ought to take a page from business where they look at processes and quality improvement and using things such as value stream mapping and lean to look at the National Contingency Plan and the way that Superfund is managed. I'd like to thank you again for allowing me the opportunity to speak before you, and I will be available to answer any questions.
Thank you. Chair, now recognize Mr. Dan Miller, Senior Assistant Attorney General, Natural Resources and Environmental Section of the Colorado Department of Law. Sir, you're welcome, and you're recognized for 5 minutes.
Thank you, Mr. Chairman, members of the subcommittee. I'm here today on behalf of the Hazardous Materials and Waste Management Division of the Colorado Department of Public Health and Environment. That's the agency that works with EPA in implementing the Superfund program, and it also implements the state equivalent of RCRA. My written statement addresses all three bills, but
if you can just pull that, just bend it so the mic's closer to your mouth. There you go.
My written statement addresses all three bills, but due to time limits, I'll probably just be able to focus on sovereign immunity and state role in remedy selection today. The Federal Facility Accountability Act broadens the CERCLA sovereign immunity waiver, a change Colorado and other states have long supported. There's simply no reason why federal agencies should be above the law. Private entities have to clean up their mess. States and cities have to clean up their mess. There's no reason federal agencies should be any different, especially since they have some of the most contaminated sites in the country. Yet federal agencies have relied on the current wording of the CERCLA waiver to argue that they're immune from the application of state laws at sites that they once contaminated but no longer own. They've also used it to argue that state laws do not apply at federal facilities that are listed on the Superfund National Priorities List. On a cursory review, the bill before us appears to resolve these concerns. However, sovereign immunity is a very complex area of the law, and we would welcome the opportunity to work with the committee, subcommittee and the committee to be sure that the proposed bill really does accomplish its intended purpose and addresses the issues that the states commonly face in cleaning up federal facilities. One of these issues that I'd like to call out is federal agency reluctance to comply with what is known as state institutional control laws, laws like environmental covenant laws. These are legal mechanisms that restrict land use at remediated sites and help limit exposure to residual contamination or protect the engineered components of a remedy. We don't have any problem getting private entities to comply with these laws, but federal agencies have long resisted their application. Turning to the state role in CERCLA remedy selection, our main concern is that CERCLA's cost-sharing structure creates incentives for EPA to choose remedies that cost less for the initial cleanup at the expense of more costly long-term maintenance. Under the current statute and regulations, EPA pays 90% of upfront remedy costs, and states pay the remaining 10%. But after 10 years, states have to pay all of the operation and maintenance costs, which can be substantial. At historic mining sites, for example, EPA remedies often rely on water treatment plants that must essentially be operated in perpetuity. These plants may cost millions of dollars a year to run. Over decades, these operation and maintenance costs will eventually overwhelm the amount of money that was spent on the remedy and change the fundamental balance of the Superfund program cost share from predominantly federal to predominantly state funded. The second concern we have is that EPA and other federal agencies implementing CERCLA sometimes resist Colorado's efforts to have its state laws designated as ARARs, the CERCLA term for cleanup standards that a particular cleanup has to meet. Once again, a common area of dispute is the state's environmental covenant law, which is frequently ignored in removal actions and sometimes even at remedial actions. With these concerns in mind, let's turn to the Federal and State Partnership for Environmental Protection Act. Section 2 emphasizes CERCLA's existing mandate that EPA consult with affected states in remedy selection. While we agree that EPA certainly sometimes views its obligation to consult rather narrowly, we're concerned, based on our understanding of the congressional process, that because this bill proposes to amend Section 104 and Section 120, it could open the door to other more controversial amendments to these sections. Perhaps there's a procedural way to limit the scope of any amendments. Section 5 of the bill creates a new exception to CERCLA's bar on pre-enforcement judicial review of remedies. This is one of the key provisions of the statute. The pre-enforcement bar prevents litigation from delaying needed cleanup actions. The proposed amendment undermines this fundamental protection by allowing any person to challenge a remedy before implementation whenever a state has simply objected in writing to the proposed remedy. We don't think this is the proper response to address the concerns we've cited above. Instead, we would address the concern about the fiscal impact to states of expensive long-term O&M by revisiting the cost-sharing allocation in the statute and regulations. If legislation is needed to address the concern that EPA doesn't consistently recognize state laws as ARARs or otherwise limits state input on cleanup decisions, it should be possible to craft a narrow legislative solution that does not undermine the bar on pre-enforcement judicial review. Thank you.
Thank you. Chair now recognizes Ms. Abigail Dillon, Coal Program Director from Earth Justice.
Thank you. Good morning, Chairman Shimkus and members of the subcommittee. Thank you for the opportunity to offer testimony this morning. I'll be addressing the proposed amendment of RCRA Section 2002B under the Reducing Excessive Deadline Obligations Act of 2013. I am Abigail Dillon. I direct the coal program at Earth Justice, and I'm also a managing attorney there. Earth Justice is a nonprofit, public interest law firm dedicated to protecting the environment. RCRA Section 2002B provides for periodic review and revision of the regulations implementing RCRA, as you know. And to be clear, the Environmental Protection Agency always enjoys the discretion to determine when revisions are necessary. As this provision is currently written, it strikes a careful balance, ensuring that regulations are updated to address evolving waste management issues while still leaving EPA broad discretion to manage RCRA programs as it sees fit and determine regulatory priorities. This bill would upset that balance in order to derail 3 parallel lawsuits that were filed to compel an EPA decision on badly needed regulation of coal ash and other waste from coal-fired power plants. As EPA acknowledges, regulation of coal ash is already long overdue, but the agency continues to delay issuance of final regulations. This delay is harming the many communities around the country that are contending with water contamination, fugitive ash dust, and the risk of catastrophic collapse of ash impoundments in the absence of effective safeguards. At the same time, ongoing regulatory uncertainty is bad for business, according to the coal ash recycling industry. And that is why the ash recycling industry and conservation groups are both suing under Section 2002B to prompt overdue action by EPA. This bill would deliberately undercut those lawsuits, leaving coal ash regulated indefinitely. More broadly, it would upset a long-standing statutory scheme for updating RCRA that has never proven to be unworkable. This bill's supporters are claiming that current law requires EPA to review or promulgate regulations within timeframes that have proven unworkable, and that this provision has, quote, only led to lawsuits for failure to meet these deadlines. However, in the 37 years since Congress established Section 2002B, a total of 3 lawsuits have been filed, and those are the 3 lawsuits pertaining to regulation of coal ash. One is been brought by conservation groups represented by Earth Justice, and again, the other has been brought by Headwaters Resources and Boro Material Technologies, two of the leading companies that market coal ash to make commercially valuable building products. The transparent intent of this bill is to undercut these lawsuits and prevent a federal court from imposing needed deadlines, one, for coal ash regulations that EPA has acknowledged are needed, and two, for a decision on the threshold question whether coal ash should be regulated as a hazardous waste under RCRA Subtitle C or as a solid waste under RCRA Subtitle D. I want to underscore it is simply not the case that this deadline has ever proven unworkable, and to Chairman Shimkus, your point about EPA's testimony, we have not had the benefit of seeing it yet, but I'm not surprised the agency is eager to avoid any deadlines whenever possible. Of course, it's an agency that contends with many deadlines, but if there's one thing that many of us can agree upon in this room, is that without deadlines, work doesn't get done. And I can't overstate the importance of addressing long-standing environmental harms that are associated with the regulatory failure to address coal ash. In 2000, 13 years ago, following years of study in the 1990s, EPA concluded that establishment of national standards under RCRA Subtitle D was necessary, quote, to ensure a consistent level of protection of human health and the environment. But in the 13 years since EPA made that formal finding, EPA has yet to undertake any of the requisite regulatory revisions that are needed to end the unsafe dumping of coal ash. This delay poses an unacceptable threat to the environment, and it perpetuates regulatory uncertainty that is unacceptable to the ash recycling industry. In short, this bill would eliminate a statutory provision that has operated for 37 years without incident, only to exacerbate the problems caused by EPA's inexcusable delay in regulating coal ash. Thank you.
Thank you. Chair now recognizes Mr. Thomas Duck, City Manager, City of Garfield, New Jersey. Sir, you're recognized for 5 minutes.
Mr. Chairman, committee members, I appear before you today on behalf of the people of the City of Garfield, a community of approximately 31,000 people located in South Bergen County in the state of New Jersey. We are multi-ethnic, multicultural, and a multi-religious community. We are a microcosm of America itself. Our city is an old industrial city filled with tired factory buildings, many of which are beyond their useful life. Many of these former industrial sites have contamination problems which are beyond the grasp of local government to handle. Back in 1983, at the EC electroplating factory in our community, there was a spill of hexavalent chromium. 3,640 gallons of chromium were released into the earth. Of that, 1,056 gallons were recovered, with the rest remaining in our soil. Over the last 25 years, the NJDEP handled this site. They made a determination in the late 1980s that no further action was required and that there were no health concerns. In early 1993, Fire Company Number 3, located in the downstream plume of the underground water table, had to be closed due to the detection of hexavalent chromium in the basement of that firehouse facility. As we have learned, once hexavalent chromium enters a building and crystallizes, it can be dispersed into the air. Scientific evidence tells us that if you breathe that dust into your lungs, it will likely cause cancer. Approximately 5 years ago, in the fall of 2008, I was contacted by the U.S. EPA. I was told that they were taking on the responsibility for the chromium spill in our city. My initial meeting was productive, and I was impressed with the competence and the genuine interest of the EPA in helping our people. We provided them with lists of residents, property owners, and tenants in an effort to get notice out to the community that the EPA would investigate and examine homes and properties in the affected area. The EC electroplating facility is located in a densely populated section of Garfield. Within the spill area, there are approximately 600 separate parcels of property. These include 1- and 2-family homes, multifamily dwellings, an elementary school, a daycare facility, houses of worship, and industrial and commercial properties. We have approximately 6,300 separate parcels of property in our city. Therefore, almost 10% of our community has been affected. Notification has been made to residents in multiple languages: English, Spanish, Polish, and Macedonian. We have conducted many public hearings with the EPA to provide information to our people and to answer their questions. The EPA's team on the ground in Garfield has been exceptional. They have answered our concerns professionally, knowledgeably, and competently. They have given reassurance to a scared populace. But despite that reassurance, property values in the area have declined significantly. With the assistance of the EPA, 400 homes and properties have been examined. Contaminated properties detected to date have been cleaned up, and monitoring wells have been installed throughout the affected area in order to fingerprint exactly where the contamination lies below the surface. To get into the ground below the EC electroplating facility, demolition of the building on the surface was required. Due to safety concerns expressed by residents that chromium-tainted dust could be released from the property during demolition, an additional public hearing was held with the staff and administration of a kindergarten through 5th grade elementary school, 1/2 block from the site. That hearing included residents throughout the affected area. The factory itself has now been demolished. The site is fenced and ready for the next phase of study to plan for the removal of the chromium that sits below ground in the water table of this neighborhood. This phase, the analysis and cleanup phase, will absolutely require continued funding of the U.S. EPA initiative in the city of Garfield. We are a Superfund site. We are a Superfund cleanup priority. We are a community living in fear that this chromium in our water table may be impacting the health, safety, and welfare of our residents. Our cleanup need is immediate. I urge your committee to continue with the necessary funding to address Superfund sites, not only in the city of Garfield, but throughout the nation. It is incumbent upon all of us as public officials to prioritize and to fund those budgetary requests that provide the greatest good for the people that we answer to. I respectfully request your support for all of the cleanup funding that is necessary in the city of Garfield and all other sites which present immediate health hazards to the people who live in or near them. Thank you, Mr. Chairman, members of the committee, for giving me the opportunity to appear before this prestigious committee.
Thank you. Now the chair recognizes himself for 5 minutes for 5 minutes of questions. Let me start with Ms. Dillon. When Earth Justice has engaged in litigation with the EPA, does Earth Justice receive compensation from the federal government for attorney fees and court costs?
Only if we prevail in a lawsuit. The federal government is like any other party, and if it...
So the answer is yes. And can you give us how much you received in 2012?
No, I don't have that figure.
Well, can you submit that to the committee for record?
Yes, I certainly can.
Great, thank you. Let me ask you. Let me follow up with you. And do you have a position on any of the other legislation we're discussing today?
Not that I'm prepared to discuss.
So there's a hearing on 3 pieces of legislation. So you decided just to testify on one?
Chairman, I was asked to address the 2002B issue, which I have particular knowledge about. I'm not an expert on CERCLA and wouldn't dare to.
Okay, let me ask a question as a citizen. If there is a state and it has a federal facility that has major contamination, do you think that the federal government should comply with the same laws that states, local communities, and businesses have to abide by?
Chairman, I'm here to testify about 2002B, and I would prefer not to wade into CERCLA, which is an area that requires, I think, tremendous sensitivity and expertise.
Mr. Duck, let me ask you that same question on just federal facilities. If a federal facility is in your community and it has the same type of problem as you just outlined by a private sector business, should that federal facility have to comply with the federal laws and in your community?
Mr. Chairman, in my opinion, a federal facility should apply just like every other facility.
Thank you very much. Let me also let me now go to Ms. Hansen. ECOS has adopted a resolution that it advocates clarification of the CERCLA waiver of sovereign immunity to ensure that federal facilities are subject to appropriate state regulations. Does the Federal Facilities Accountability Act accomplish the purposes of ECOS resolution?
According to our understanding of the bills, we do believe it addresses concerns expressed by the states in that resolution.
Does ECO support the Federal and State Environmental Partnership for Environmental Protection Act?
I will have to double check on that.
Well, that's
Yes.
the names. We have the REDO Act, the State Partnership Act, and we have the Federal Accountability Act, 3 pieces of legislation in this oversight hearing today.
And which one were you asking about? I'm sorry.
The state part, in essence, the state Partnership Act, giving states more of a role in the whole process. As
I'm sorry, I got my pages out of order. We address certain we agree with certain parts of the bill, the consultation with the states and the credit for state contributions.
Mr. Steers, can you describe the role states currently have in administering the CERCLA cleanup program?
Yes. Many of the states work with EPA on oversight and also assist the U.S. government through cooperative agreements on doing site assessments and preliminary investigations at the very front end of the CERCLA process where we identify sites. So the states have a role in working with U.S. EPA in identifying sites that may be risked. We also have a role in using state Superfund contracts for the process of state input and oversight, at least to be able to offer that. Not always used, but we do get that opportunity.
Do you have any decision-making authority under CERCLA?
I will say it's very limited, and typically what we would hope by these bills is that we have more authority, especially when it comes to determining whether to even put a site on the NPL or with the remedy, especially with the selection of a remedy.
Yeah, and I think you followed, that was my follow-up question. Why is it important that states at least have some role? So it's really the NPL issue too. You may want to more rapidly identify a location on the NPL, and you can, correct me if I'm wrong, by empowering you all, you may be able to leverage that and get a site on the NPL sooner?
We may be able to do that. We have states understand their sites the most and have the greatest boots on the ground with being able to identify what our priority sites are. So having the ability to suggest sites for the NPL is also something that I think we all as states would support where it's appropriate.
Great. My time's expired. Now Chair yields to Mr. Tonko for 5 minutes.
Thank you, Mr. Chair. And again, good morning to our witnesses. I'd like to examine one legislative provision in the bills before us that may be particularly controversial. Section 113 of CERCLA includes a statutory bar on pre-enforcement review of cleanup remedies. My understanding is that when this committee crafted the law decades ago, this was considered a very important key provision. Mr. Miller, your testimony refers to this bar on pre-enforcement judicial review as, and I quote, one of the key provisions of the statute. Can you explain why that provision is so important?
Certainly. The concern was that without the bar on the pre-enforcement review, anyone would be allowed to challenge an EPA decision on a remedy and thereby delay the implementation of the remedy potentially for years while the litigation runs its course. And so obviously there was a concern that responsible parties at these sites might seek to delay their obligation to clean up the site. I don't know. But it could go the other way. It was everybody is precluded pretty much from challenging remedies prior to their implementation, environmental groups, industry, states. And
so is the result then of that perhaps added or extended hazardous and human health concerns?
Well, because the statute bars that type of litigation, it allows the remedies to be implemented in a timely fashion, and then people can sue after the remedy has been implemented to challenge whether it was a correct decision or not. But in the meantime, you've addressed the human health concerns by implementing the remedy.
So then what problems would arise if Congress did indeed lift this bar and allow judicial review of cleanup remedies?
As I read the provision, anytime the state has expressed an objection to a remedy, it would allow any entity to sue to block implementation of the remedy. And so at sites where that occurred, cleanup could be delayed for years.
And an increased bit of litigation that would result.
It would, I mean, yes.
So, Mr. Miller, it appears that the way the proposal is drafted, even a responsible party would be able to go to court to challenge a remedy before its implementation.
That's how I read the provision.
And a responsible party could have a financial incentive to go to court, delay a cleanup, and argue for a less protective cleanup remedy. Is that correct?
Yes, that is correct.
So I guess someone could argue that despite those drawbacks, this provision might still be worth it if it resulted in better cleanups. But this provision would result in judges deciding the best way to clean up Superfund sites. Does anyone on the panel think that judges would make the best technical cleanup decisions? Anyone?
I guess it depends on the standards they're applying. Typically, judges give some deference to agency decisions within the area of their expertise, but the main concern here is with the timing of the litigation and the timing of when the cleanups would happen.
Mm-hmm. Anyone else that might have an opinion on having it fall to a judicial interpretation? Anyone? If not, Mr. Dutch, you are a city manager trying to get a site cleaned up in your community. What would be your advice to the committee when you hear that we are considering a legislative proposal that could increase litigation and, in fact, delay cleanups?
My primary concern as a city manager is really the health, safety, and welfare of the people who live in that area. Any litigation that would slow up the process would certainly is certainly not desired. Anything that allows the filing of more litigation could present a problem in my community. Right now, there is no litigation. We are proceeding. Litigation would slow us down.
And, Mr. Chair, the basic policy behind Superfund is that polluters should pay for their pollution. Might I respectfully share that I think we should be very careful about potentially creating new avenues for litigation that can allow polluters to delay cleanups and argue for weaker protections. They have a financial incentive to do so, but that does not align with the public interest.
He's gone.
With that, I yield back.
The gentleman yields back. I think we have time for one more round of, not round, but one more question before there's votes. There's 11 minutes left on the floor. So the chair now will turn to Mr. Murphy for 5 minutes.
Actually, Mr. Chairman, I'm assuming I wasn't going to get to, so I'll pass, go to somebody else. I'm still preparing my questions.
Well, let me just, in the majority side, does anyone want to seek time for the 5 minutes? Mr. Latta?
Well, thank you, Mr. Chairman. Pardon me. Yeah, and thanks very much for our witnesses for being here today. I really appreciate it. And if I could start with Ms. Hanson, if I may, kind of following along the chairman's lines. The question is, has ECOS, has it adopted a resolution regarding the fact that states are co-regulators with the federal government and that there should be a meaningful and substantial involvement of the state environmental agencies as partners?
We have.
Okay. And does the Federal and State Environmental Partnership for Environmental Protection Act accomplish the purpose of the ECOS resolution?
In that it addresses consultation with the states, it does.
Okay. And let me ask, just follow up with that. Is that consultation very, you know, I came from state government. I was in the legislature for 11 years, and I was also on the receiving end. I was a county commissioner for 6 years, so I was getting it from the federal and the state. So does the ECOS support the Federal and State Environmental Partnership for that Environmental Protection Act? Does that?
I didn't follow
Okay.
your question. I'm
Does
sorry.
the ECOS support the Federal and State Environmental Partnership for the Environmental Protection Act?
We support parts of the bill. The consultation, the state credit for other contributions, and placing the sites on the national priorities list.
Okay. And just following along those lines, in your testimony, it notes that the EPA is not obligated to listen to state input about the remedy selection for sites on the national priority list. And to what extent does the EPA include the states in selecting a response action?
I believe that would vary state to state. If you wanted specific numbers or responses, I'd have to get back to you.
Okay. Well, when you say it varies from state to state, is it a wide variance, or how would you rank that?
Again, I would have to check on exactly what that would be.
Okay. And if I could turn to Mr. Steers, if I could ask you, do federal agencies, including the EPA, implementing the circular routinely comply with all applicable state requirements? And if not, why not?
Well, we often identify, and we always do identify the ARRs and the state requirements. Typically, though, the federal agencies, especially on formerly used defense sites, for example, the agencies tend to use sovereign immunity as a get-out-of-jail card, if you will, trying to circumvent state requirements that may be more stringent, and especially considering them in other media such as the NPDES water programs and the Clean Air Act. So states have authorized programs and have regulatory requirements that we end up having delayed federal actions because of debates on sovereign immunity.
Okay, but in those, who typically determines what state requirements are applicable?
Can you repeat the question again?
Yeah, who typically determines what state requirements are applicable?
You know, the states are only in a position to offer these up, and at the end of the day, EPA and the federal agencies determine which ARRs that are going to be used.
Thank you, Mr. Chairman.
Would the gentleman yield?
I yield to the Chairman.
Thank you. I had a follow-up question for Mr. Duck. I come out of local government too, so appreciate folks in municipalities, counties, townships, however. If you were required under state statute, I'm assuming cities in New Jersey are empowered by the state constitution, which I'll incorporate as a city. Is that correct?
Our city is incorporated. I don't understand, Mr. Chairman.
Well, the state gives you that authority to incorporate, to become a city by the state constitution. So what if the state passed law and said, city, you have to review all your ordinances every 3 years? Would that be helpful?
It probably would be helpful. New Jersey is known for having many old laws.
So you will. So I can then call to the state of New Jersey and say, I've got a city manager who says it's going to be helpful to him to review all his local ordinances every 3 years. And if not, then people who are adverse to that would be able to take the city to court because you haven't reviewed those laws in 3 years. Is that what you're asking for?
I'm not asking for that, Mr. Chairman.
No, but the point of the question is, one of the pieces of legislation says that the federal government, the EP, has to review every regulation within 3 years. And if they don't, whether it's a good regulation or not, they have to review it. And if not, then outside parties can sue them. Would you like the same type of venue for your local community?
It would slow down our ability to run the government. If there was a review process.
Yes, sir, and very costly.
Absolutely.
And possibly litigious.
If I had to make a choice between doing that and spending the money on the cleanup, I would spend the money on the cleanup.
Amen, brother. Thank you. I'm going to recess the committee till after votes. We will reconvene about 15 minutes after the last vote. What do you think, Mr. Greg? Fine? 15 minutes after the last vote. The hearing's recessed.
Oh, that's cool. Congratulations. Yeah, yeah. You project. We haven't met before. Nice to meet you. Nice to meet you too. Hi, how are you doing? So this is the legislative director for Mr. Tom Carl. Hi, glad to meet you, Abigail Dillon. Thank you for the time. It's important, that's for sure. Well, it's a good thing. Oh, thank you very much. Hi. Yeah. Yeah. Well, right. Yes, I mean, not everyone has expertise at all with those. Yeah, exactly. I was just feeling bad that I couldn't help out, but I just didn't want to say the wrong thing without being prepared. Sure, sure. Do you think that Bill will be able to come back? That we'll get more members returning? Okay, perfect. Is there anything that you'd like me to highlight that I haven't done yet? They don't. Well, I mean, I can say what they've told us their review consists of. I mean, when we did a FOIA request to see their review.
Hi, I just want to introduce myself. I'm Anthony Dragna with Bloomberg BNA. I know we've spoken about a million times over the phone.
Yeah, so glad to finally meet you. Do you know Andrea Delgado?
I think we've met before. Excellent. I just wanted to ask quickly, are there any updates on the definition of solid waste case?
Oh my goodness, I wish there were.
So no word from the agency?
No.
Okay. Thank you.
I know. Well, I mean, that's not crazy. We've had a couple of really good ones. Yeah, I know. It's simple.
Yeah, you would. That'd be great. So it's not recently.
Yeah, it was a couple months ago.
Okay. Okay. Well, nice to meet you.
Nice to meet you too.
We'll look for Representative McKinley to ask some questions.
I know.
I did, but I was already out here, actually. Yeah. Came out, my sister lives here.
Oh,
Came out
great.
to visit her.
Well, you couldn't have picked a nicer time.
Yeah, it's really,
gorgeous.
it's been pleasant.
I bet it's just getting beautiful in Colorado now, too.
Yeah, we're way behind on the trees stuff. Like, the trees are still pretty bare.
I lived in
Well, they were when
Montana
I
for years, and May was like, March everywhere.
Right.
You know.
Yeah.
I'd like to call the subcommittee back to order, and I believe I was the last to ask questions before the recess for votes, and the next questioner on the Democrat side is the gentleman from Michigan, the Chairman Emeritus, Mr. Dingell, is recognized.
These questions go to Mr. Miller of Colorado Department of Law. Mr. Miller, relating to the amendments in Section 108 of CERCLA, how many states have promulgated the financial responsibility requirements?
I don't know the answer to that question for
Well,
all
you
areas,
submitted
but
for the
certainly
record.
any state that has a RCRA program or a state equivalent to RCRA would have financial assurance for.
But the answer is very few, if any. Is that right?
With respect to, I'm not sure.
Okay. Well, let's go to the next one. I don't want to be unfair to you. Relating to the amendment to Section 2002B of CERCLA, which eliminates the requirements of current law that require the administrator to review regulations every 3 years. This requirement has been a part of the federal law for over 30 years. Do you believe that the effort to change this long-standing provision have anything to do with litigation relating to coal ash regulations? Yes or no?
It's my understanding that it does.
Thank you. Now, sir, does anything prevent a state from obtaining funding for its activities on Superfunds and things of that sort from fees, taxes, or other revenues to clean up toxic waste sites in their state?
They would just have to do it in compliance with whatever their state laws are.
So there's no obstacle in any federal law to prevent them from doing so?
Not that I'm aware.
Okay. Now, this, if states then choose to exercise this, they have total control over the remedy selected or the removal action taken. Is that not so?
It depends on whether the federal government's also acting. If the EPA
No, but
is
if
in
the
there.
state initiates its own program
Right.
using its own funding, it can then proceed to function under its own law, right?
That's correct.
Okay. Now, let us draw our attention to Section 113H. This provides new opportunity for lawsuits where a state simply writes a letter objecting to a remedy selected by the president. After such letter is posted by the state, it would allow under this provision, it would allow the responsible party who polluted the site to litigate the challenge and to challenge the remedy. Is that not so?
That's correct.
I believe that, Ms. Dillon, I have trouble seeing it. I believe
Yes.
you were the same view. Is that correct?
Yes.
Okay, thank you. Would it, now the next question is, would it allow an environmental group also to challenge the remedy if they could get a state to write such a letter? Yes or no?
Yes.
Okay. Who would in fact be barred from such an effort? In other words, getting the governor to write a letter. Anybody could do it, right?
Anybody could try to do that, yes.
Good. Now, in a situation where the state wants the most gold-plated remedy, which might require the excavation and disposal of hundreds of tons of contaminated soil, so its future operation and maintenance costs for which the state is responsible are less, could this new lawsuit provision be used to leverage the federal cleanup decision, up or down?
It would provide the states more leverage in their discussions with EPA as to what their.
I'm not trying to trap you, but the answer is yes,
No,
right?
well, clearly it's trying to give the states more leverage in their negotiations with EPA.
Okay. Now, this also affords opportunity for the process to be delayed, does it not?
The way the provision is drafted, because it affects the 113H bar on judicial review, it does.
So again, the answer is yes.
Yes.
Now, what happens to the citizens surrounding the community? Here we got a lot of folks living around the site, and they are daily being exposed to these hazardous substances, and they want the site redeveloped to create jobs and to make their lives and that of their families and children more safe. So now we have a process where the decision is going to be litigated, and this can take years in the federal court under this new lawsuit provision. Am I correct?
Yes, it could lead to lengthy delays in cleaning up sites.
And one of the problems, I believe, with Superfund is that these things are litigated till hell freezes over. Isn't that right?
Circle litigation can go on for a long time.
And it's having a prodigious delaying effect on the cleanup of all of these poisoned sites, and it's creating huge difficulty in terms of seeing to it that we make the progress that the people desperately want in disposing of these sites, and it's costing more money. Am I right or wrong?
Well, with the pre-enforcement judicial, the bar on pre-enforcement judicial review in place that limits litigation that would delay cleanups.
So
Most of
the answer is it permits a splendid opportunity to obfuscate the process, delay the cleanup, and cost a lot more money in litigation, which is a prodigiously expensive undertaking, right?
Right, it would open the door to a lot more litigation.
Okay. Now, Ms. Hanson, you...
If gentlemen would suspend, the clock got started late, and you're already 30 seconds over.
Am I incorrect? I got 26 seconds?
And the clock got started late, so it's really 1 minute and 26, but if the gentleman wants to ask unanimous consent for additional 30 seconds for...
I will accede to the wishes of the chair.
Thank you.
I thank you.
Thank you. Chair now recognizes gentleman from West Virginia, Mr. McKinley, for 5 minutes.
Thank you, Mr. Chairman. Just a matter of housekeeping, Mr. Chairman, and for the panel, I think we've worked under the idea in this committee, in my time, is that we were to have all testimony submitted within 48 hours or prior to 48 hours before testimony. And Ms. Dillon, were you aware of that requirement from Earth Justice, that there's a 48-hour restriction?
Mr. McKinley, my understanding is there was only an agreement reached late yesterday on what witnesses would be here, and I only received my invitation to testify yesterday afternoon.
Okay, so there was some reason, because we only got your testimony last night about 7:30. And
yes, there is a reason.
So we didn't have a lot of chance, but I think it was interesting because quite frankly, I thought, after reading your testimony, I thought you were going to testify at a different hearing, because it really had little to do with this hearing, when 10 of the 15 pages had to do with fly ash, and then when they quizzed you, someone earlier, you didn't have expertise in all three, but you did have about the fly ash. So I was interested. I hope you come back when we talk about fly ash, so we can have a meaningful adult conversation with that.
I'd be delighted to.
But in the meantime, I am curious I'm trying to reconcile your testimony. On page 4, you say that in any deadline enforcement case, the agency has ample time on and on, and there's no reason the courts will impose unworkable deadlines. But yet then in your own brief, you said you think they should be forced to do it within 6 months. Can you explain that a little bit better, why there's a contradiction in your testimony and in your legal brief?
Certainly, there isn't a contradiction. In our briefing, we take the position that EPA has had decades to come forward with revisions of the regulations that should address coal ash, and has failed to do that. It has proposed a rule in 2009. We think that the agency could expeditiously wrap up this rulemaking process that's created uncertainty for everyone.
Whether that there seems to be a bit of a moving target, because I am curious. I think some testimony, maybe Mr. Dutch, you mentioned it about some of the pollutants, but the legislation that we passed 4 times out of here last year would have resolved a lot of the issues that you're referring to about groundwater contamination, because under the legislation we passed, it called for new liners underneath all new impoundments that would take care of this, and called for strict requirements over dam safety and water monitoring, all those things. But yet your group opposed that. So I'm just curious about that, because you seem to be wanting it both ways when the legislation was addressing it. But I think the real sticking point, if I'm correct, is over primacy. You want the EPA to control the landfills versus the House's position, and with quite a few from the other side of the aisle, we're looking for a resolution by allowing the states, and the states themselves have said they're prepared to do that. So you worked against a resolution to the very problem you're addressing.
We want environmental protection in whatever form it comes in.
Well,
The House bill would not provide it.
We gave it with putting liners underneath it and dam impoundments so that we wouldn't have another Kingston, because it wasn't what they were containing was the problem. It was a failure of a dam to collapse that caused that.
Respectfully, we disagree, but that's a bill that's not before the committee today.
Thank you. So I was just curious, because you came and that's all your testimony has been about fly ash. So I'm just curious to see what you know about it, other than just you want it your way and not in a way that the committee, because we had an earlier discussion with Administrator Stanislaus, and he showed a very positive attitude about getting this thing resolved this year. And I'm very encouraged with the possibility we may very well, through bipartisan, get some kind of resolution, but you seem to be stuck outside the table. And I would suggest that perhaps instead of looking for perfect, if you're willing to compromise with us, we'll all come to some resolution and resolve this matter and remove the stigmas associated with the recyclable materials. By time, apparently I've got a couple of seconds that you want to respond.
We would certainly be interested in any action by Congress that would resolve the long-standing water pollution problems and fly ash, air pollution problems, and dam safety issues. So far, that has not
already said that
materialized.
he's willing to work with us and try to get that resolved?
I'm sorry.
You're not aware that the administrator said he's willing to work with us?
If the administrator is willing to work with Congress and Congress is willing to come to a solution that actually works to address coal ash, we would be the first people to endorse such a solution. So far, that solution has not materialized.
Thank you very much.
Gentleman's time's expired. Chair now recognizes the gentleman from California, Mr. McNerney, for 5 minutes.
Thank you, Mr. Chairman. Ms. Hanson, could you tell me how many times the state has been added to the national priority list without the concurrence of the state of location? How often a site, has been added?
I don't have a number right off. We would have to look into that to get an actual number of times.
My understanding is that there haven't been any. And I was wondering if that was because there was a tacit agreement in place, or is it because of financial constraints at the EPA that states are not adding sites or not wanting to add sites to the national priority list?
I don't know specifically why that would be.
Well, my district has 2 Superfund sites, and I was going to ask your opinion on what it would take to get action on those sites. Would it take additional EPA budget money? Would it take legislation here in Congress?
Not knowing anything about those sites and where they have fallen in looking at risk and things like that, it would be hard to make any statement on how you get those.
Would the gentleman yield? Are those on the national priority list right now? Do you know? I mean, I'm just
Yes.
curious.
Yes, they
Okay.
are. In fact, I can tell you what they are if you want to see them.
No, because part of this debate is if states have bad sites, they're trying to use this venue to get on the national priorities list. It's not the flip side.
Okay, you're reclaiming my time. Ms. Dillon, some have claimed that the deadline set out in Section 2002B of the Solid Waste Disposal Act has proven impracticable, and it results in an avalanche of lawsuits. As you mentioned in your testimony, there have only been 3 lawsuits under that provision in the last 29 years since the law has been on the books. Do you believe that the EPA has been under excessive burdens because of this review requirement?
No, there's no evidence to suggest that it has been. These 3 lawsuits all relate to a single issue, and that is regulation of coal ash, and that's something that's been an issue that EPA has recognized needs to be addressed for the last 2 decades. And even in that court case, EPA has said, we recognize we need to revise these regulations. And so now it's just a question of getting it done. And I would submit that without a deadline, we won't see regulations to address this problem in the foreseeable future.
Thank you. Mr. Miller, you mentioned the issue of federal financial responsibility requirements potentially preempting state requirements. Do you believe the EPA has the discretion to address that issue under current authority?
My understanding of the existing law is that EPA does have discretion to write rules that would meet the intent of Section 108 to provide financial assurance for releases of hazardous substances without preempting state laws that address related but separate issues such as RCRA, closure of hazardous waste impoundments and the like, or mining bonds under state mining laws to require reclamation. But they also have the discretion to preempt.
Thank you. Ms. Hanson, again, You've expressed support for protecting state financial responsibility requirements for hard rock mining. How many states have adopted financial responsibility requirements for hard rock mining?
I do not have that number with me today.
Okay, you'll need to get that to us
Okay.
then. Has ECOS conducted a comparative analysis of those state requirements to know how the requirements are similar and how they are different?
We have not.
All right. I understand that we may be marking these bills up in June. Will you commit to provide the committee that information for the record before the markup occurs?
We will do our best to get that information as rapidly as we can.
Okay, thank you. I yield back.
Gentleman yields back to time. Chair now recognizes the gentleman from Florida, Mr. Bilirakis, for 5 minutes.
Thank you, Mr. Chairman. I appreciate it very much. Thanks for holding this hearing. There are 16 Superfund sites in or near my Florida congressional district, some of which have had that status for several years. The length of time it takes for EPA and the Florida Department of Environmental Protection to coordinate is one of the reasons the process takes so long. The question is for Mr. Hansen and Mr. Steers. You have mentioned that EPA's coordination practices are not consistent across regions or state to state. What legislative recommendations do you suggest to ensure every state receives equitable treatment? Whoever would like to go first.
Yes, I think in order to solve especially with remedy selection and being able to get some more consistency across the country by EPA regions, I think having EPA have more skin in the game, if you will, may help that concurrence be taken a little more seriously. It's not to say that they're never concurring with or they're never taking the information and the recommendations the states have, but it's not done consistently, and the results, when it's not done on either poor design or performance of some of these long-term systems, are saddling the states with a lot of cost. My pipe example being one, but there's many out there. And I believe if EPA had more skin in the game by, if they want to minimize or marginalize a state's recommendations, then they should be on the hook for some of the long-term O&M that goes on with these sites. It's a way to ensure that the state's voices are heard for the long course O&M that can result from not taking our comments into account during the remedy selection.
Thank you. Ms. Hansen?
Yes, ECOS always advocates for a stronger state role in working on environmental issues with the federal government, and only required to, it's not required, actually, it's just a policy that EPA consult with the states, and we have said in our testimony that we would like it to be, we approve of it being required.
Thank you. Ms. Hansen, you noted in your testimony that providing a mechanism for states to list sites that meet the listing criteria would make certain parties more willing to negotiate with the states and resolve cleanup issues without having to use Superfund money. Can you please explain that? Elaborate, please, if you will.
I think if sites knew that they could have a state come to them in addition to just the federal government, there's not just one mechanism, but more than one mechanism or more than one group, that they would be more willing to talk to states. If they think it's only the federal government that's going to come in on a site, on a complex Superfund type site, they are not going to talk to the states. They're going to wait for the federal government to come in.
Again, for Ms. Hansen, EPA has indicated the agency has a policy of not listing a site on the national priorities list over the objection of the state. Is that policy applied consistently across the regions, and shouldn't it be a requirement that EPA not list a site over the objection of the state?
We find that there are regularly variations state to state, region to region on all sorts of work with the EPA, so having something a requirement ensures that it does occur consistently.
Anyone else wish to comment on that?
And I would agree. I think a lot of our states, we feel like we're being pressured through the governor's concurrence process into putting sites on the NPL, when quite frankly there are potentially other solutions out there that could facilitate a cleanup much faster than just being an on the circular process. I understand there are some EPA regions where they're actually going through looking in newspaper articles for sites that potentially could be on the NPL as a way to try to keep the ball rolling with getting sites enrolled in the program. And that's where I feel that and our association feels that having a process where you go through prioritizing in the state's sites and what the state knows about the economic and environmental conditions in the community. In a previous testimony I gave in front of this committee, I mentioned that we have some success stories of watershed approaches that are used sometimes to clean up several sites without having to go through the long process on the NPL. And we had one in my former state of Ohio that I worked for, which was a very big success story where a lot of contaminated property along the Ottawa River was actually restored and cleaned up without the Superfund stigma attached to it, because all the responsible parties came together, worked together, and facilitated a cleanup on their own with the state using a voluntary cleanup program as a way to restore that watershed.
Thank you very much. Thank you, Mr. Chairman. I yield back.
Gentleman's time's expired. Chair now recognizes the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman, for holding the hearing. I'm glad to hear that this will be the first of at least 2 hearings looking at the successes and possible shortcomings of RCRA and the Superfund site. Our district in East Houston, Harris County, Texas, has a number of Superfund sites close in proximity, including the San Jacinto waste pits and the U.S. oil recovery. With my colleague, Congressman Ted Poe's support, the EPA has been conducting studies and begun very early stages of cleaning up the San Jacinto Rivers site. The U.S. oil recovery site was listed as a proposed addition to the NPL in 2011. From what I've witnessed at the San Jacinto waste pits, I believe the EPA is making great strides in the Superfund program. However, as a former state legislator, I'm sensitive to the cost federal decisions are placed on state and local governments, and hope this hearing will highlight the importance of the EPA work with the states as closely as possible and weigh the long-term cost of remediated Superfund sites on state governments. Mr. Miller, the National Contingency Plan sets out how cleanups are to be conducted, and it includes an expectation that institutional controls will be used to supplement engineering controls as appropriate. In your experience, has that expectation been borne out in the Superfund cleanups?
No, that's actually an area where there's been quite a bit of difficulty. EPA has paid increasing amounts of attention to institutional controls in recent years and has developed some policy guidance on it. But it's an issue that we struggle with, particularly at sites that are cleaned up under removal authority. And it's an issue that's always difficult at federal facilities. Federal agencies routinely resist the imposition of these institutional controls at their sites. And it's kind of a puzzling position to me, because the institutional controls really don't cost very much at all. It's just creating a legally binding document and monitoring it, compliance with it. But the federal agencies have resisted our efforts to impose it at a number of sites. We've recently had some luck with the Department of Defense has come around, and they're happy to use a mechanism that we have in Colorado that a lot of other states don't have at DOD facilities, but we are continuing to get resistance from the land management agencies.
The Superfund is currently written prioritized as treatment that significantly reduces the volume, toxicity, and mobility of the contaminants over response actions that do not have that effect. It also requires a cost-effectiveness analysis of response actions, including the cost of operation and maintenance for the entire period during which such activities are required. Mr. Miller, are your experience of these statutory requirements consistently met?
It's a balancing act at every site.
My experience with the 2 sites in our area, the U.S. oil recovery site, it's been frustrating because of it's in Pasadena, Texas, and in our district, because of the responsible party has been very unwilling, in fact, has disappeared on us. So that caused other problems. Are these areas where we might want to conduct more oversight? And do you think that sometimes just asking the right question can result in improved performance?
It's an issue that varies from site to site. I do think that, particularly with respect to the long-term maintenance costs in Colorado, we're looking at paying roughly $8 million a year to operate water treatment plants at two of our larger mining sites. And over time, that O&M cost is, going to eventually exceed the cost of the original remedy. So this is an issue that the states actually sued EPA over when the National Contingency Plan was promulgated in 1990 over the cost-sharing provisions. EPA wrote a rule that interpreted the statute to require the states to pay 100% of the operation and maintenance, and it was the state's position that the statute actually required a 90-10 cost split, 90% federal, 10% state, for both the initial cost of the cleanup as well as continued operation and maintenance. So earlier today when I referred to changing the cost share provisions, it's changing the allocation of O&M costs, I think could encourage EPA to pay more attention to remedies that would minimize really the long-term costs of these sites.
Thank you. I know I'm almost out of time, Mr. Chairman. I agree with Mr. Miller. There are existing concerns over EPA's enforcement of Superfund, particularly in light of our hearing yesterday in our Energy Committee on the President's budget cuts to the Superfund. And I think it's our subcommittee's responsibility to oversee the EPA actions. Hopefully the EPA must work with state and local governments as closely as possible to weigh the long-term cost of the remediated sites. But taking a heavy-handed approach will only make the problem worse and open up Superfund to more litigation, which obviously doesn't help us clean up the sites. So I appreciate the time this morning.
Gentleman yields back his time. Chair now recognizes Chairman Emeritus Mr. Barton for 5 minutes.
Mr. Chairman, I don't have any questions. I'll just make a general comment. These three bills to me look like common sense efforts to reform and improve CERCLA. And I know that former Chairman Dingell seemed to have some pretty serious reservations, but hopefully we can work through those and have a good open process in the markup and move the bills. I mean, no federal law was set in stone, and certainly the times have changed and some of the imperfections in CERCLA need to be changed, and I think this is good faith effort, these three bills, to do that. So I hope that the subcommittee can move forward in a bipartisan, open way to move these bills. With that, I yield back, or yield to you.
Gentleman yields back. Now, Chair now recognizes the gentlelady from the state of Illinois, Ms. Schakowsky, for 5 minutes.
Thank you, Mr. Chairman. Mr. Tonko asked if I would.
That's great.
Okay. Mr. Dutch, I want to thank you for being here today. Your testimony really provided a picture of how Superfund works in the real world to protect people and communities from the risks and costs of contamination. It's so important that any changes this committee considers to Superfund builds on its success, helping communities like yours instead of undermining it. And that's why I really am concerned that the bills before us today actually undermine our ability to help communities like yours. Although the EPA couldn't be here, they did review the bills, and they tell us that the bills will increase litigation, divert funds, and generally delay needed cleanups. So, Mr. Dutch, how long has your town been fighting to clean up the contamination at the Superfund site?
The spill that I spoke about earlier took place in 1983. It was managed by the New Jersey Department of Environmental Protection for the next 25 years. There was a determination made by them in the late 80s that there was really no further problem and no further concern. We were very fortunate in 2008 that the U.S. EPA was handed the case by the NJDEP. They came in. They have begun the cleanup. But my concern is we have now fingerprinted where our problem is, but we need to clean up. And the only way we can clean up is if there is continued funding for the EPA to do that. Right now they're doing the analysis and analysis phase to determine what is the best way to clean up. There are monitoring wells, 46 of them, that have been drilled throughout this 600 parcel area. those monitoring wells are between 8 feet and 400 feet deep. So the analysis is being done, but a determination needs to be made as to the best way to clean up. There are a number of alternatives that the EPA has discussed with us. They are all expensive. And every other community in the country that has a Superfund site, in particular a site like this that is under residential properties, is threatened. So we do need help.
So this is your water supply for your town?
Our water supply is not impacted.
Okay.
The problem is that there is a fairly high water table in this particular area. So when the water table rises, the hexavalent chromium can seep into basements. When it seeps into basements and it dries, it crystallizes, and in that crystallized form, when it becomes airborne dust, it becomes dangerous. So the sooner we can get it out of the water table or treated in the water table, the sooner our people will be safe.
So if the money for the cleanup were just not available from the EPA, does your town have any other way to get the site cleaned up?
Our community we are one of 70 towns in Bergen County. We are on the socioeconomic scale, our people are working class people. The city does not have that kind of a budget, nor do we have the technical expertise that would allow us to address this problem properly.
So would you oppose changes to the Superfund that have the potential to limit the funds available for cleanups like yours, or have the potential to significantly delay any cleanup?
We certainly would oppose that. The sooner the cleanup can take place, the better. The less obstacles that are placed in front of the EPA, the sooner we can move forward.
Thank you very much.
Thank you.
I wanted to ask Ms. Dillon, we have a local issue. I don't know, we may disagree on that, Mr. Chairman, but you probably know about the Badger Ferry that was recently granted a 2-year permit to continue operating on Lake Michigan in a settlement with the Environmental Protection Agency. This has to do with coal ash being dumped right into the lake. And every time it sails between Wisconsin and Michigan, the Badger Ferry dumps 4 tons of coal ash into the lake, and each year more than 500 tons of coal ash is dumped right from the ferry into the lake. I wondered if you could share your thoughts on the Badger Ferry settlement that would allow another season for them to continue dumping.
Well, I'm not familiar with the details of the settlement, but I certainly know about the issue, and it's one of the notorious examples of what can happen when there isn't proper regulation of coal ash. And I think it underscores what my message has been to the subcommittee today, which is please don't take away the one backstop that we have to ensure that EPA is forced to address this. And I think the settlement that you point up suggests that the agency is not going to take the action that's needed to address even the most notorious problems like the Badger Ferry if it doesn't have a deadline.
Gentlelady's time has expired. We appreciate the first panel for being here and for your testimony. The subcommittee stands in recess until Wednesday, May 22nd at 10:15 a.m.